I'd like you to remember that this is a presentation for wealthy people. The rest of you could just go watch something else. In fact, if you're wealthy, but you're probably going to lose your wealth, then you could go watch something else also. Remember, there will be no flash photography or intermission. Please don't make a lot of loud noises that would interrupt others. The show will begin in 1 or 2 or 5 metric minutes. Please send any questions on the question box, and they will be cheerfully answered by me. The presenter is not very good, so maybe drink a cup of coffee and take notes so you don't fall asleep during the presentation. Thank you very much, and we'll see you in a little while. Hey, through the, oh, and thank you very much. Oh, thank you. All right. Through the magic of electronics, here we are today to talk about estate tax planning for the wealthy, what you need to know. If you are new to these Saturday at 11 presentations, then you have my apologies because they're not all that good. But we cover a lot of very important things. So hopefully it's not the presentation, it's the content that you're looking for, and you can ignore the dummy's arm back there. We do these every Saturday at 11. They do not qualify for continuing education credit because they are not good enough. You can ask a question by going to the question panel. It's the upside down pyramid, and nothing against pyramids, but it's the upside down one. You can click in your question, and thank you very much for any of your questions. Okay, we have a YouTube library, and if you go there and click 1,000 times, we will get $1. So if you could go there and click 1,000 times, we do appreciate it. There is, sorry, I'm not sharing screen. Hey, sorry about that. I didn't realize I wasn't sharing screen. Okay. Can you see me? Hopefully you can see my screen now. Okay, our YouTube video library includes Marty Shankman's Part 1 talk on humanity of estate planning, or the human aspects of estate planning. We're going to show Part 2 at noon, but if you want to see Part 1, just Google Shankman, S-H-E-N-K-M-A-N, human, H-U-M-A-N, and that'll bring you to the video of that. And if you watch it 1,000 times, we'll make maybe 10 cents or 12 cents. Okay, on to the presentation. The first thing I want to mention is that there are many, many techniques that are simply not being used. They're not being used because they don't come to mind, or they're not being used because people don't realize how effective they can be, or they're not being used because, candidly, our profession has not done a great job in teaching all of the members of our profession what all of these techniques are. So as far as estate tax planning literacy, I hope that today I'll give you a lot of good information, some different ways to look at it, but I can't cover all 400 and some odd slides. So we're going to do a Part 2 in a few weeks, but in any event, where was I? Sorry, this thing's a little bit of flippy dippy today. There is, oops, hello, don't be so touchy. So you're here Saturday, April 23rd. On the 30th, we'll be talking about dynamic planning for professionals and their entities. On the 7th, estate tax planning for the wealthy, what you need to know, Part 2. And then our guest speaker will be a real ventriloquist, not a mediocre one like me. And then Saturday, May 21st, we're going to be covering an estate tax planning topic, plus social justice fund, activating trust-based philanthropy with some local community foundation experts that I really look forward to speaking with. So let's go here. I just want to mention Bob Panoff emailed me and said, how do you define wealthy? And I emailed back and I said, wealthy is somebody who can afford to pay my fees. But how do you know if you are going to have an estate tax issue? And I have a spreadsheet here, and the spreadsheet shows you in green what the estate tax exemption is for a married couple who has not done gifting. It's $12,060,000 each. Double that to $24,120,000. If one spouse dies, the other spouse may be very sad, but their exemption can go up to as high as $24,120,000 if the first dying spouse has not used any of their exemption and allows in their will, or at least doesn't disallow, having their personal representative make what's called a portability allowance election. But if the first spouse dies, leaving a $12,060,000 portability allowance to the surviving spouse, and the surviving spouse remarries, and the new spouse of the surviving spouse dies, then the surviving spouse's portability allowance is reduced or increased to what it would be from the new spouse if the new spouse allows it in his or her estate planning. So you can't really bank on having $24,120,000. You can kind of bank on having $12,060,000 increase seen each year by chained inflation. And what is chained inflation? It's complicated, but it's about 2/3 of what real inflation is, at least historically. But in 2026, as you see here in yellow, the estate tax exemption goes down to half. So assuming that it goes up by 2.5%, this married couple is only going to have a total of $13,644,000 of exemption, $13,644,000. So they may want to use their whole $24 million now, because then if it goes down, they'll have used the $24 million, it won't have disappeared. So having people in a position where they can do that before 2026 is a good idea. But it might go down sooner if the Democrats retake both the Senate, the House, and Disney World. If they could retake all three of those places, then the exemption could go down to 1/2 of what it is now. That is what was proposed last year and came within 1 or 2 or 3 senators of passing. Of course, it didn't pass, and it's not on the drawing table now. The latest proposals, which we're going to go over, do not reduce the exemption, but that's not to say that it won't come down in 2026. So here, for all you good people, when you open up this Excel spreadsheet, and you can just email me if you have not gotten it or you don't get it, we have up-down arrows for you. This is what our office calls is Allen proof, that I don't have to enter numbers. I can just increase or decrease the numbers using my arrows. So if you're a married couple and you want to start this at only $10,500,000, and you expect your assets to grow at 7% a year, and you're going to save $90,000 a year for the next 20 years, then where do you hit the estate tax? Well, under the present system, you don't hit it until year 19. Not so much to worry about. But if the exemption goes to half in 2026, you're going to be estate taxable in 2026. And if it goes to half in 2022, which won't happen, then you would be estate taxable sooner. But a lot of you on this talk are way above that. So, oops, most of you will not get a 15% rate of return. Some of you will get an 8.5% rate of return. And then the net worth could be at 20 million, and you can see a lot of estate tax there. So that's a little toy you can play with anytime you like. let's go to another slide, and we'll come back to the qualified personal residence trust. What I heard the first day of my estate tax planning course at the University of Florida in 1983 with Professor Doug Miller was that the estate tax is a voluntary tax. And that really surprised me because at the time, the estate tax exemption was a whopping $325,000 and everything above that was taxed. And once the client got to $3 million, the estate tax rate was 55%. So what was this professor telling me when he said that the estate tax is a voluntary tax? And what he was saying is you can avoid a lot of it even with a 325 exemption, and then you could give the rest to charity and you could completely avoid estate tax. But the bigger point he made was that the majority of families who pay estate tax didn't have to. The majority of families who pay estate tax simply didn't do their planning. And that's a good thing for us because we enjoy preparing estate tax returns and sending in checks to the US government for large percentages of the client's wealth if we were not the estate planners for the family. But when we are the estate planners for the family, we want to get to a zero estate tax or as close to a zero estate tax as possible. And for those of you who know this area well, and for those of you who don't, I'll mention that two of the things or three of the things we do, just so you know, is we make intercompany loans or intercompany sales between the clients and trusts that they establish. And right now, the interest rates are going up. So if you do a loan in April, then the interest rate on a 9-year note, 1.87%. The interest rate on a note over 9 years, 2.25%. So if I could give $1 million in assets to my granddaughter, and it may grow at 8%, and she gives me back a note for 2.25%, she could like sign it in crayon, then the difference of about 6% is going to be out of my estate and could be enjoyed by her many, many years up the road. In addition, if I'm 70 years old, I could do what's called a self-canceling installment note, a SKIN, which is S-C-I-N, not S-K-I-N. Sorry for the spelling error there. But if I loan my granddaughter $1 million, she signs in crayon. And if she pays me 6.624%, and then she's lucky enough that I die before the 12th year when the note balloons, then that whole note is out of my estate for estate tax planning purposes. So I do tell clients, and you can tell clients, if you get a bad diagnosis, call your spouse first and me second, because there's things that we can do to make lemons into lemonade. And another example is I could give my granddaughter $1 million and she could give me $85,000 a year the rest of my life, or she might choose to not give me a single payment. As long as I have better than a 50% chance of living a year at the time I give her the $1 million, she could sign an annuity agreement saying that she'll start making payments in year 8. Of course, the payments would be much bigger than $85,000 a year, but they would go only for my lifetime. And then if I die before year 8, she owes me nothing. I've made no gift, and there's no estate tax. So just to warm you up, you see that there are things that we can do, but that the interest rates are nudging up. So we want to be vigilant. If you have promissory notes now in place, we want to reduce the interest rate, or at least consider reducing the interest rate to 2.25%. And the note will typically be, at least for the life expectancy of the client, if you want to lock that in. So as I said, you have to run the math in these areas. We have much more complicated models to run the math with. But if you don't run the math, you can't really understand what we're doing here. And I'm trying to understand why these slides keep repeating themselves, but we will get to where we are going. Now, fellow estate planners, when you sit with the client, explain the rule of 72 which is simply that if you get a 7.2% rate of return on investments, they will double in value in 10 years. Or if you just get a 7% rate of return, they'll double in value every 10.29 years. So, you can sit with the clients and say, you're not touching your investments. They're worth 10 million. In 10 years, they're going to be worth 20. In another 10 years, 40. In another 10 years, 80. Would you rather be owed a 2% promissory note so they don't grow in your estate so much? And the client will think you're smart, whether you're really smart or not. Now, when you have a married couple, you can do a joint skin or a joint. With a joint skin, both people around age 70, there would be a 21-year balloon, and you would only have to use 3.205% interest. So if you're going to do a $10 million sale for a 2% note, you might consider doing a 21-year note for 3.2%. And then if these children are lucky enough to lose their parents within the first 21 years, there will be significant estate tax planning. So what are we planning in the face of? We're planning in the face of a proposed billionaire tax that would actually hit everyone with a net worth of $100 million or more. And I think that will cause some quick discount planning where families will get their assets into different vehicles to get their net worth under 100 million. If you're at 100 million or more, then what this tax would do, one, if it's ever passed, and two, if it's constitutional, which is very questionable, is you would be taxed today on your capital gains as if you sold all your capital gain assets. So if you have a $200 million net worth, and if you sold all your assets, you would have 100,000 capital gain. Then you'll pay the tax on the $100,000 capital gain. You'll consider the amount due in taxes when they pass the law, and you'll pay it over 10 sad years. So that would be the billionaire tax. And I hope it doesn't pass. But if it does pass, then it'll probably take 2 years for the U.S. Supreme Court to say that it is unconstitutional. Based on what I've seen, it doesn't look very constitutional to me. Maybe it's just a political move by Democrats to show the public that they would like to try to tax the wealthiest, but in reality, they're proposing it in a way that won't work. Maybe there's a wink wink going on between the Democrats and the super wealthy. Who knows? Someday we'll find out. Then let me go forward here. Yeah, I'm sorry about the touchiness of the slides today. They're just angry with me. It must have been something I said. But in addition to this, the proposals that came out of the Biden administration in February would give a $5 million exclusion for that capital gains tax on the billionaires, and would also change the estate tax laws to a certain extent, where irrevocable trusts that are disregarded for income tax purposes, and many dozens of you who are on this webinar you've established irrevocable trusts for your children, grandchildren, great-grandchildren, sometimes for your spouses, whether you like them or not, and you are paying the income tax on the income of those trusts. And those trusts would be grandfathered in on the day that this new law would pass. But if you did a new trust after that, and you pay the tax on behalf, for that new trust, then that would be considered a taxable gift. So sometime before the next election or shortly after the next election, at least by then, give your estate tax lawyer or other planner a call and make sure that you have the right things in the right trusts in case they are grandfathered. Now, I wanted to mention the REAP trust, which is what we refer to as a reversible asset protection trust. If your client thinks that they want to make a gift of their exemption, but they're not absolutely sure whether they want to make a gift of their exemption, then they could set up a reversible asset protection trust now and use up the exemption. But then then it would merge into their existing dynasty trust, or it would be a dynasty trust. But then if the estate tax exemption goes away, then the client can get the assets back, but they will have used their exemption. So it's not a perfect solution. A more perfect solution would be what we call a disclaimer trust. And we have Ed Morrow's article here on how to do a disclaimer trust, where you would put the assets into a trust and it would use your exemption unless a disclaimer is made within 9 months of when the trust is funded. And this can also be done using a QTIP trust, also known as a qualified personal residence trust. So we just want to make sure that people understand that. Now, another thing in the Biden Green Book, that's what his tax proposals are called, they're called the Green Book, would be that certain transfers of appreciated assets exceeding $5 million per person, when you transfer the asset, it's considered as sold, similar to the Canadian system. So if the law passes and I give $10 million of appreciated stock to my daughter, the first $5 million is no problem, but the next $5 million will be considered to have been sold by me at fair market value, and I'll have to pay the income tax in addition to any gift tax that may be owed. So hopefully this won't pass, but it is out there. So if you have appreciated assets and you would like to have them out of your estate, if the dynasty trust that owes you money has unappreciated assets, you may want to swap those assets, or you might swap them with your spousal limited access trust, which I guess would be called a spousal swap, which could mean something else but shouldn't. So these things are definitely out there, and they are threats to wealth without question. So the estate tax charitable deduction, usually you cover the estate tax charitable deduction at the end of a presentation when there isn't time to say anything about it. So to satisfy Professor Miller's instructions that we offer clients a zero estate tax plan, we can use a disposition of anything that would be subject to estate tax to a foundation. So you die with 30 million worth of assets, 24 million pass estate tax free for the married couple. The rest, the 6 million difference, simply goes to a foundation named for you, formed after your death, run by your children, to do good deeds, including paying your children, grandchildren, and great-grandchildren compensation for actually waking up in the morning and doing charitable things, like teaching, like inventing, like artistic endeavors, things like that. Alternatively, if you're not that charitable, you can do what Jackie Kennedy did in her will, and you can leave a charitable lead annuity trust. And the short definition of a charitable lead annuity trust is it's a trust, you probably knew that from the name, that gives a certain amount to a charity every year for a term of years, and then what's left at the end can go to your children estate tax free. And with all the smokes and mirrors, what can happen is you die and that 6 million excess goes to the charitable lead annuity trust. It pays certain payments to your family foundation formed after you die, controlled by your children or any other charity you like. And then at the end of the term, which is usually between 12 and 20 years, What's left goes to your children estate tax-free, and that is commonly 50 to 70% of the value going to your children estate tax-free. So instead of more, that's actually more than what your children receive in some cases if Uncle Sam is going to take 40%. And that is after the taking into account the time value of money. So that is a little bit about the estate tax charitable deduction. There's another estate tax play that I thought I had a slide on, and it is called the administrative note. And with the I'm sorry, these slides keep returning to page 40, and I don't know why. With the administrative note, what I do is, let's say I have $50 million worth of assets, and I don't want to pay estate tax. So I die. 24 million pass estate tax free. Now there's another 26 million of assets. Those 26 million of assets go to a charity, but before they go to the charity, my children buy them for a $26 million, 2% 30-year note. So the charity gets a $22 million 30-year 2% note, and my children get the assets. And then the charity says, what on earth am I going to do with a $22 million 2% note that doesn't balloon for 30 years? I know what I'll do. I'll see if this family will give me all the money earlier in exchange for a discount. So this would be a public charity. It could be controlled by the family if it's a school, a church organization, a medical research organization, or a clinic that qualifies as a hospital. Then it's a public charity controlled by the children. A valuation report says that that $22 million note is worth $10 million. The children give the charity the 10 million, the children keep the 22 million of assets, and there's a zero estate tax. So that is called the administrative note exception to the self-dealing rules that allows that to happen. So those are, just gave you 3 important charitable techniques. Number 1 was the charitable foundation that you can simply leave assets to. Number 2, the charitable lead trust. And number 3, the administrative note foundation. And if you're not fluent with those, even if your client has complicated assets, businesses, and things like that, those techniques can all work. In addition to using a charitable remainder unit trust to defer the income tax that might occur in a liquidity event. In other words, if you're going to sell your business, put it in a dynasty trust, then the dynasty trust sets up a charitable remainder unit trust, then the business is sold, no income tax paid for the first 14 years, estate tax avoidance takes place. It's a beautiful thing. Everyone's happy. All right, I have on page 69 a protective trust logistical chart. This is what happens after death. So here's a technique. Don't forget to use an irrevocable life insurance trust. If I own life insurance on my life while I'm living or within 3 years of my death, then that life insurance is going to be subject to estate tax. Now, you may say, that's not a problem. I'm going to leave the life insurance to my spouse. Well, if your spouse gets the life insurance, then it's going to be estate taxable when your spouse dies. So it's still a problem. So quite often, we put the life insurance into what's called an irrevocable life insurance trust. And it can benefit your spouse and descendants, whether you like them or not, and never be subject to federal estate tax. Now, when you put money into the life insurance trust, that's a gift. You can use your $16,000 per year gift tax exclusion using what's called crummy withdrawal powers. There's nothing wrong with them. They're named after a taxpayer in the case, estate of Crummy. Too bad his name wasn't Excellent, then they would be excellent withdrawal powers. Now they're just Crummy withdrawal powers. But that's the irrevocable life insurance trust. And then something else you'll see in these slides that I can't control because they have a mind of their own is that if I am making big life insurance premium payments and I don't want to use my estate tax exemption for those premium payments, then I can use what's called a split dollar advance arrangement. And a split dollar advance arrangement in most cases is just a fancy way of saying that I'm going to loan money to the life insurance trust at the long-term applicable federal rate that applies at the time of each loan. And the life insurance trust doesn't have to pay me back until it borrows on the policy or the life insurance matures. That's an interesting word we have in our estate planning vocabulary. Instead of saying when you die and you get the life insurance money, we say when the policy matures. So I put $1 million into a life insurance trust. It buys a $10 million life insurance policy on my life. The trust owes me $1 million, but it doesn't have to pay me until I die. So if that is hopefully in 30 years, I've been able to take $1 million investment, and when I die, I'm only going to get back maybe $2 million with a 2% rate of return, and this trust is going to get $8 million estate tax free. So that would be the advantage of using an irrevocable life insurance trust. Now, for the wealthy, a lot of people don't realize or they don't think about the fact that you could also do a private placement life insurance policy. And these are not nearly as popular as they should be because oftentimes the sponsors charge a whole lot more than they need to. So the client looks at the charges and says, oh my gosh, I'm not going to pay that much. But what you can do is put a lot of cash into a private life insurance policy, appoint an independent investment advisor, and then that independent investment advisor, in my example, could buy $1 million of commercial real estate, which may hopefully have a 6 to 8% rate of return. And how much income tax does a life insurance policy pay on its income? And the answer is 0. So now the client has commercial real estate under a life insurance policy, and and there's also a death benefit within the policy. You could just picture that the insurance carrier puts together an entity which owns the shopping center and also holds what I will call a lifetime term life policy, a death-only policy. Some money goes into that death-only policy to keep this as a life insurance policy under the tax law. And then the client could get their $1 million back by withdrawing $1 million from the policy if they want to get that back, and that's tax-free. And then any money above that in the policy that they would like to have use of during their lifetime, they can borrow tax-free as long as you leave a certain amount in. And then when the client dies, all the loans go away, and the children are very sad that the father died, but very happy that now they get the shopping center, and there's no income tax on any of the income that the shopping center has generated. I'm not sure offhand if they get a fair market value basis on the shopping center when it comes out of the life insurance trust, but this is simply an example. A life insurance trust could also own a business entity. So you have to be very careful with the self-dealing rules, but there are, many nice things that you can do with life insurance. Now, when this married couple, first spouse dies, the first $12,060,000 of assets can go into a credit shelter trust, also known as a family trust or a bypass trust. which will benefit the surviving spouse and descendants without ever being subject to federal estate tax on the second death. And then when that second spouse dies, she can direct where the family trust goes, as between the descendants, if you want to limit it to descendants, or charity, or wherever it would be directed. But if it is not directed, then it goes into separate, usually separate irrevocable trusts for each child. And then the child could be a trustee, he could be sole trustee or co-trustee, get what the child needs for the magic words, health, education, maintenance, and support. And then when the child dies, there's no estate tax. So this could go under Florida law, if you're a Floridian, up to 360 years. But if Governor DeSantis signs the new bill that was passed by the Florida House and the Florida Senate before they all went to Disney World on vacation, then we'll have a 1,000-year rule against perpetuity period here in Florida, putting us equal with South Dakota, but still behind Delaware, which has an unlimited number of years, which would probably get old after a period of time. So the alternative to this that estate tax planning lawyers hear a lot about is just use portability. The reason is because when the children have the benefit of these assets in the generation skipping trust that came from the family trust, there's no step up in income tax basis. Whereas if this money was left to the surviving spouse and the surviving spouse left it to the trust for the children, then they would get a new fair market value income tax basis when the surviving spouse died. We believe that it's better to use the credit shelter trust. But in your drafting, if you're one of these lawyers drafting these, or you're these people who review their documents, who reviews a document? Well, the trust company reviews it. It'd be good if the CPA reviews it. But what would be really good, but is very rare, if you, the client, would actually pull out that document and read it. And I say that tongue in cheek, not because I recently had dental work, but because a lot of you on this webinar did read my documents and gave me some really good advice on my documents. You either gave me new verbiage, which I've added to my documents, or you told me to make them shorter, and I've ignored that advice, as you know. So portability, not so good, but what I was getting to is when you draft the documents, make very sure that the client family, within 9 months of the date of death of the first dying spouse, can decide, do they want to use the credit shelter trust, or do they want to use portability, or a part of each? And you can do that by putting a Clayton Q-tip provision and or disclaimer provisions into your documents. So I hope that you consider that. Now, from the point of view of the inheritor, my friends at Oceans and Oceans, OSHINS, is a law firm in Nevada. They have really done a lot of good writing and a lot of good modeling on the inheritance trust. And this is, would I rather inherit directly to my own name, where I could lose it in a creditor situation, or a divorce situation? Don't tell Marcia I said that. Or I did something stupid situation, which can happen at all ages. So I stress for my clients, please leave the assets not directly to the children, leave them into a trust for the health, education, maintenance, and support of the child. The child can be the sole trustee if you insist on that. The child can direct where the assets go on death, as long as it's limited to only being exercisable in favor of anyone or anything but their estate themselves, their creditors, or their creditor's estate. But more often, you can limit it to family members or possibly family charities. So that is the inheritance trust. Now, if you want your parents to leave your disposition to you in that type of trust. In the old days, I used to just go crazy trying to get the parents to understand what we needed, and then trying to get their lawyers to understand what we needed, and then trying to get it drafted. It was just about impossible. So now what I do is I just draft the inheritance trust. It's called the John Smith Inheritance Trust. It's signed by John Smith as trustee and as grantor, and it says, I'm requesting but not requiring that if my parents leave me an inheritance, please leave it to John Smith as trustee of the inheritance trust dated February 3rd, 2022. And then I just send a copy of that trust to the parents or their lawyer and say, just change one sentence here in your estate plan, leave it to the John Smith Inheritance Trust, and then everyone will be happy. Most importantly, John Smith. So, and then John Smith's spouse won't leave him because John Smith's spouse doesn't want to lose that inheritance, the ability to live on that inheritance that is in the inheritance trust, but not in joint names with the spouse. So if you're going to show the optional Clayton Q-tip trust, you can do this by using page 79, where now the client on the first death has 9 months to decide whether to remodel the house, whether to get a new car, and whether to have a family trust or what's called a Q-tip deduction trust, where you can still have the portability allowance apply. And I've got some of our language on portability. Now, I wanted to talk also about the JEST trust. And the JEST trust, for those of you who don't need creditor protection planning and have joint assets and you'd like to get a step up in basis on the first death and fund a credit shelter trust, we kind of invented this. I say kind of invented it because it almost existed, but nobody really realized it. And what it does is, instead of each spouse having a separate revocable trust, as you would see if I could find it here, if I could get the, instead of each spouse having a separate revocable trust, we have this one revocable trust called the JEST. And with the JEST trust, when one spouse dies, up to $12,060,000 worth of assets can pass into one or two credit shelter trusts for the surviving spouse. And everything above that goes to a marital deduction trust. So, for example, if the married couple only has 15 million of assets, and one of them is a neurosurgeon with a short life expectancy, and the other is a soccer coach, well, if we expect the neurosurgeon may die, and we'd like to get all 12 million into an estate tax exemption trust, a credit shelter trust, then if we put 12 million worth of assets in the neurosurgeon's name, we're going to possibly lose those to a malpractice case. So we could put them in a JEST trust owned 1% by the neurosurgeon, 99% by the soccer coach. Now the neurosurgeon dies, and the first 12,060,000 go into credit shelter trusts for the soccer coach, and everything gets a step up in basis, even though the soccer coach owned 99% of it before the neurosurgeon died. So now the soccer coach has $12 million in an exemption trust for the soccer coach and his or her children, and the soccer coach can go marry another neurosurgeon now and do it again. So that is the JEST trust. And for those of you who are in the profession, and by that I mean the legal profession or the accounting profession, not the first profession, you can look at this chart and think about what works best for your clients. If you're in a community property state like California, Texas, or Wisconsin, then you may want to consider switching from your community property treatment to a JEST trust, because under community property, if one spouse is sued, the creditor can reach all the joint assets. But also in a community property state, when one spouse dies, the community property assets get a full step up. Well, the JEST trust gives you better creditor protection and, in our opinion, gets you the step up. Now, the IRS may not agree with our opinion, but there's good theory behind it, and we've given you citations to articles about the JEST trust, and also about what works best when you're trying to get the step up planning. So enough of JEST and enough of portability versus credit to shelter trust planning. Plenty for you to review there. Letter ruling 2022-06008 came out in March. And this is a really nice little IRS ruling. And by the way, if you want to know when an IRS ruling came out, the first 4 digits will tell you the year that it was released. So this was released in 2022. And in this ruling, there was an irrevocable trust left by somebody for family members, and it was deemed in the best interest of the beneficiaries to give an older family member a power to direct assets to creditors of his estate. And the reason for that was that on the death of this older family member, the trust will get a new fair market value income tax basis. So for example, I set up an irrevocable trust for my wife, Marcia, and our descendants, and I put my office building in it. That's a gift. It's out of my estate. The rent goes to Marcia as trustee. She can reinvest it. And what if we give Marcia's father also the ability to receive distributions from that trust in certain circumstances, like when the moon turns into cheese, and we also give him the power to direct trust assets to creditors of his estate. And then he passes away. Now we get a new fair market value income tax basis on the building. We could take component depreciation all over again, take regular depreciation on the part that can't be component depreciation, and those deductions will flow through to our personal Form 1040 income tax return. So the IRS generally approved this arrangement in private letter ruling 2022-06008. So that's good news and bad news. The good news is you can do this. Now, the formula clause is I give my father-in-law a power to direct trust assets to creditors of his estate, but only with the permission of our next door neighbors. You can put that in there. And only to the extent that the assets in the trust plus his personal assets do not reach $12,060,000. So if he has $1,060,000 of assets, then he would only be able to appoint up to 11 million. Actually, it would be 10,999,999 of assets. And if we have more than that in assets in the SLAT, then his power would only be over the most appreciated assets in the SLAT. So that is the new basis planning that has become very, very popular. Now, page 116 is the life insurance pages that I was looking for. So you've got some life insurance there. Now, something very important happened in the split dollar area this year, and that is the Levine case. And Marty Shankman's write-up on the Levine case is really good. One thing I want to point out is what's going on is instead of doing a split dollar life insurance advance for the policy on my life, let's say I put $1 million into a life insurance trust to buy a policy on my daughter's life. And let's say she's 40 years old. And I'm going to get paid back my $1 million with interest at 2.2% in 40 years approximately, or 50 when my daughter passes away. What is that $1 million note worth if I die in 5 years when my daughter has a 35-year life expectancy? It's not worth $1 million. Is it worth $500,000? Probably not. So in the Levine case, that's what Mrs. Levine did. She had made a lot of money running a dollar store, like a five and dime store called Pennies, but it wasn't J.C. Penney's because she wasn't French. So she made a lot of money after she sold the store in real estate, and then she loaned a lot of money to an irrevocable life insurance trust to get life insurance on her children. Then she died on cue, and the IRS and the taxpayer agreed that the discount for the split dollar arrangement was huge. I don't remember what it was, but it was probably about 70%. But the IRS said because of a technical rule, something known as 2036A2, Internal Revenue Code section 2036A2, you can Google it and read it. You don't have to give money to the Cornell site if you don't want to. That's usually the one that comes up. If you do give them money, tell them it's from me. But because of section 2036A2, I didn't stutter there. That was a technical issue in the computer. But because of it, and because, believe it or not, Mrs. Levine had the right to join with the life insurance trust to amend the split dollar agreement, it was determined that if she had that power, that the life insurance policy would be in her estate at its cash value, not the fair market value of the note. Now, in Mrs. Levine's situation, that provision wasn't in there, but an older case, Cahill, Cahill, which I think was from 2020 or 2019, the court said because the split dollar agreement allows the advancing party, Mr. Cahill, to amend it with the consent of the trust, we're going to consider the trust to be in his estate. So we now have to go to all our split dollar agreements and take out the provision that says that the parties to this agreement can amend it by mutual consent, which is a really silly thing considering that under state law, any two parties to an agreement can amend the agreement with mutual consent. So we were worried that every agreement would have a 2036A2 problem, but under the Levine case, which is very well drafted, it's a pleasure to read that case. I wish all judges would write like this judge wrote as far as style. He said, hey, based on older Supreme Court cases, the ability to amend an arrangement simply because state law gives you that a right is not necessarily a 2036A problem. That is Levine, and thanks to Marty Shinkman for letting me plagiarize. I gave Marty credit for writing the article because I found a typo in it. I didn't want to be credited with the typo. There are other life insurance planning techniques that we have. We don't necessarily have to go over them today. What I do want to go over today, because we see it and use it the most often, and we'll be building on this when we come back on Saturday, May 7th, and hopefully the slides work better, is the spousal limited access trust and the installment sale. So the spousal limited access trust, as I mentioned, is a trust that I can form and fund for my spouse. And because I gifted it and I am not a beneficiary, it is out of my estate for estate tax purposes. But I can still have benefits from that trust. The first benefit is it can pay half of our living expenses as long as I'm still married to my spouse. The second benefit is that it may loan money to me at arm's length. The third benefit is that if it's properly drafted and it's in an asset protection jurisdiction like Nevada, then I could name my best friends as trust protectors, and they might be able to add me as a beneficiary of that trust if my net worth ever goes down and I'm having financial problems. So that trust is creditor proof. That trust is estate tax proof. That trust makes my spouse happy. If your spouse is happy, you're happy. If my spouse leaves me, then it can have a floating spouse provision. which means that if my spouse swims away and another spouse shows up, then that new spouse can be the beneficiary in the discretion of the trustee, and again pay half of our household expenses if there could ever be a spouse that would want to share a household with me. But what do I put in my spousal limited access trust? Well, quite commonly, you will make, in this example, a $700,000 seed capital gift. So that's $700,000 in cash or $700,000 in stocks, bonds, something that's easy to value. And then that SLAT can buy assets from me in exchange for a long-term, low-interest promissory note. So like I told you in my example, I put $1 million of stocks in that SLAT that I think will appreciate at 8% per year based upon the last 65 years of experience in the stock market. And the SLAT gives me back a note at only 2.2% interest. Now, when we made this chart up over a year ago, it was only 1.35%. So you see the interest rates are coming up. It's time to get this planning done if I haven't already. So my spouse may want to do the same thing with a trust for our descendants. Not a SLAT for me because of the reciprocal trust doctrine. Our law firm, we don't do reciprocal SLATs. We think they're risky for reasons that I can explain later. We think the IRS would consider each spouse to be the grantor of the SLAT for his or her benefit because creditors would be able to do that. So anyway, what could this couple do? A lot of times clients say, what should I freeze? What should I give away? The answer is everything possible. Put all that stuff in an LLC. The LLC is worth $20 million. Keep 1% voting. One spouse sells 49.5% non-voting to the SLAT for only $7 million because you take a nice discount. We took a 30% discount for lack of marketability and lack of control. And then here, the other spouse sells 49.5% non-voting member interest to the descendants trust. And now this couple, instead of having 20 million of stuff, they have 14 million of notes that are not going to go up in value. The clients are going to pay the income tax on all the income generated under the LLC. They're going to get their note payments of about $280,000 a year, use that to pay their taxes on the LLC. This can work beautifully for an S corporation that has high earnings. And what does this look like 10 years from now? Well, there's two ways. First of all, if you want, we could all do this 10 years from now. Send me an email. We'll schedule it for 10 years from now. We'll go over it then. But to give you a preview, in 10 years, because of the rule of 72, the LLC will have 40 million in assets, and let's say it dissolves. So the spousal limited access trust gets $20 million. It owes a 7 million note. It has a value of $13 million on a $700,000 gift. Yes, ladies and gentlemen, you heard that right. It's colossal. It's stupendous. It's the installment sale to the spousal limited access trust, et cetera, et cetera. I'm going to answer a couple of questions now. We're going to cover the rest of this on Saturday, March 7th, when the slides will actually work. Now let's see a couple of questions. Okay, from Alan. I like your name, Alan, but your mother misspelled it with 2 L's. Okay, 80-year-old couple with a lot of real estate as the main assets want to leave an irrevocable trust with a discount for leaving all to 3 children. They want to retain income until they die. Mechanism. Well, if the reptile brain could consider the payments on the promissory notes that I just showed you to be income, then that works perfectly. You put those apartments or whatever that property is into the LLC, value it, sell it to these trusts for a discount, And then the parents could receive a management fee from the LLC if they're going to do work there. But it's important the payments on those notes can be equal to what the income is from the property, but better that it not be. Better that they just take what they need to live on from those notes, not the income, because of 2036A, and that could fit them like a glove. Okay, question from Robert. When the first spouse passes and leaves all assets in his or her name to the surviving spouse, does the value of the deceased spouse's assets reduce the estate tax exemption? No, because you get the portability allowance, as I said. From Ray, can a trust like the JEST use a step-up basis? I thought only individuals get a step-up. Yeah, a trust can get a step-up if an individual is considered to be the owner of that trust for income tax purposes under Internal Revenue Code section 1014. In my humble and apparently incorrect opinion, if you have a trust that's disregarded for income tax purposes and the grantor dies, I personally think there's a step up, but people a lot smarter than me think there's not. And if you want our white paper on this, let me know. But if you're not so sure and you have somebody else who could become a power of appointment holder, then under Internal Revenue Code section 2014E, you can get that step up. Okay, one last question from Peter. We're in a non-community property state and have South Dakota irrevocable trusts. Is there a distinction between a South Dakota trust and a South Dakota community property trust? Yes, with a South Dakota community property trust, either half or all of your assets are in that trust are exposed to creditors. Whereas with your South Dakota typical irrevocable trust, nothing is exposed to creditors. So you may want to consider making your South Dakota irrevocable trust into what Ed Morrow calls the OBIT, which gives you a new basis in income taxes on death by putting Uncle Charlie in there as a beneficiary and giving him a power of appointment. Okay, well, in the words of Monty Python, if you have enjoyed this presentation half as much as I have, then I have enjoyed it twice as much as you have. I'm sorry about the technical difficulties, but it's great to be able to blame human error on computers. And now, with the magic of technology, we're going to see part 2 of Marty Shinkman's beautiful talk on human planning and estate planning. And if you want to see part 1 later, just go to the YouTube and put in Shinkman, S-H-E-N-K-M-A-N, human estate, and it comes right up. So Brittany, do your magic. Let's watch Marty. Marty, how do you handle allocating assets between children when one child has a lot more need than the other and the tendency to leave everything equally? What is the normal result that you see? Because I do feel sometimes, well, I'll leave each child $1 million. I have 3 million. Well, one has special needs and one's a doctor. What's the normal outcome there?
Well, let me first answer what you didn't ask. What is the normal process for dealing with it? I would say in the vast majority of cases, and I don't have statistics and I've never seen statistics, people leave everything equally. And equal, as you know, and I think this is where you're going, is not necessarily equitable. And I think that people as a default leave equally for the same reason that many of the clients that come into our office want to save tax, even if they don't face a tax, because it's an easy answer. You don't have to delve into the tough stuff. I've even seen some clients leave the kids with most money, the family business, which is worth even more. Well, my son is running the business. Let him have the business. Well, what about your other kids? You know, what I try to suggest is that you have to evaluate labor and equity. And if you have a business, for example, there's 2 components to it, labor and equity. If a child's in the business and another child's not, compensate even handsomely the child that's running the family business but why is the other child's birthright less than the one that's in the business? And you know what? Just having the discussion, I think, can lead to a better result because at least it starts to play it out. And the issue that you're raising about equality, inequality, equity, what's fair, what's necessary, that issue, Alan, as you know, but to say it to everybody listening, that is often the most profound, influential issue on what happens to that family. And I have what I often call the Thanksgiving conversation. You know about the Thanksgiving conversation?
Yeah.
Alan, you got to get up on this stuff. If you do the plan the way you just suggested, client, will your family be able to sit around the Thanksgiving table together? And a lot of times the answer is, what are you kidding me? They'll kill each other. And that's not usually what the client says, but it's what we point out because they didn't think about the real ramifications. They only go this far as saying, well, my son's in the business. I want him to have the business. Well, but what does that do to everyone else? Or let's take an example like you said. One child's very successful and the other child has, let's not say special needs because that's maybe easier to relate to emotionally. Let's say one of the children has an addiction issue, a gambling and drug issue. So the kid that's doing well may be resentful of mom and dad giving anything to the kid with the addiction issues because, geez, look how much money you've spent over the decades trying to bail him or her out. They've got more money than I have, and now you're going to give them more to support their problem? There can often be anger and resentment, and because you've seen it, and it's something that I think is hard for clients to envision because they haven't seen it because they're not in the same profession where we see it over and over and over. So often what happens is while the parent is alive or whoever the benefactor, uncle, aunt, whatever, while the parent or benefactor is alive, the emotions are kind of kept below the surface. The minute last of mom and dad go, all this pent up anger or resentment, it all comes flowing out. And I know you've seen it. It's tragic. It's tragic. But I think that is, and when I next time revise my list on human aspects of planning, that's going to be the first topic. What do you do? I think you need to have a discussion. What do you do? Maybe if there's a child that's special needs, if the family's worth 30 million and there's 3 kids and you want to leave equally, you may do an analysis and speak to special needs consultants and find that leaving 10 million for the particular special needs child, depending on their needs and their issues and challenges, maybe you cap it. I've seen sometimes at 5 million. So maybe you leave 5 million to that child just because any more is not going to matter if they're receiving government aid and the 5 million is more than enough of a backstop. And you have an analysis, an objective analysis to support that and divide the 25 million between the other two. But that's easy because it's analyzed. But when you have a kid with an addiction issue and there's 3 kids and like you said, $3 million, do you leave $1 million to each? And 2 kids are very successful. One's on Wall Street, one's a physician. And this other kid has got problems. I'll tell you an approach I've used in some cases. I'm not sure $1 million would be enough, but let's say, take the same example, but let's say the client's got $5 million or $10 million. Let's use 10. So maybe what you do is you leave each of the children $2.5 million. And the child that's got the addiction issues, you put the money in trust. What I would suggest is you put each child's money in trust. The doctor, the Wall Street person, they should have it in trust because they want it out of their estate. They should want it in trust because of asset and divorce protection. The kid with the addiction issue needs it in trust to protect it primarily from themselves. But meanwhile, if everybody's stuff is in trust, even if the parent wants to give it outright, I encourage make a similar trust for everybody. Maybe the only difference is the 2 children who are doing well, they can be co-trustees or sole trustees of their own trust. And the child with issues, maybe I like to name an institution because you can't call them at 3 in the morning and scream until you get the money. But if all 3 children have the money in trust, the child with the addiction issue doesn't have to feel resentful because, but for the one minor change that I've never seen them notice, like who the trustee is, everything's in trust, brother. Why are you concerned? We got treated the same way you did. But what you might do with a $10 million estate, just as a hypothetical, 2.5, 2.5, 2.5, set up another trust with 2.5 million and put somebody objective in it. The family attorney that's been, or accountant that's known the family for 30, 40 years and knows the drill. Let that be a discretionary trust where it can be used if the child with the drug issue is willing to really go to rehab and really help themselves. Maybe we can help support that. If a child in the other families, and this is very important, and this is why I think you have to be careful when you make disparate distributions. Too often, the family will assume that if the child that has an issue, and we'll keep our same example, 3 kids, 2 very successful, 1 with several addictions and problems. How do you know that the child that's the successful physician, that she may not have a special needs child, or that she may not suffer a health issue? My wife was diagnosed at age 50 with multiple sclerosis, and it truncated her career by over a decade. Would it be fair that her brother, who may have issues, got more money because he had issues, and now she has a diagnosis of a major health problem that she couldn't even control? So the answers are not simple. And taking a one-dimensional approach, here's the snapshot we have now. You know, Alan, and any of the advisors on the call know, and I bet the clients really know too, the world changes so dramatically. You know, look back at what was going on 10 years ago. I mean, look at how the world has changed in 10 years. So we need to have flexibility because we just don't know what the future holds. And I find that it's very hard to get clients to focus to the level that we've just talked about, because it gets a little vaguer, it gets a little more complicated, it gets a little more expensive. Let me ask you the question back. What do you think of my approach of saying 2.5, 2.5, 2.5, and make a pot trust, because we just don't know what's coming down the pipe?
I think that's a really very good solution. That's very good. I want to mention that I really discourage clients from having siblings be involved with each other's inheritance, though. I
No,
mean, oh, I'll just have
100%.
older brother be the trustee for everybody. That's a great, then there won't be a Thanksgiving for anyone. So I like the idea of a separate pot trust as long as it's a truly independent party who does not reveal confidential information. Because I say to clients, would you want your sibling to be your trustee, or would you want your sister-in-law or brother-in-law involved with your decisions? Because that is what happens there. Marty, you mentioned protecting an LGBT child. What were you referring to there? What special considerations may apply there?
So I have an example that I'm working on right now, I can tell you, but let me step back and give sort of a generic answer. One of the problems is, for example, if you have a child who is or may or has transitioned, male, female, whatever, what happens to the bequests in the documents? If you leave a bequest to your son John, and John is now Jane, did the way you write that bequest make it lapse? What if there's discretion and you named Uncle Joe, good old Uncle Joe, solid guy, you know, just salt of the earth kind of guy? Will he take offense at the lifestyle choices your child has or may make in the future, so that he would be vindictive in how he makes allocations? The statistic that I've heard, and I've heard it innumerable times, so I suspect it's true. I haven't seen the source, but is that something like 50% of trans people are physically assaulted because of their lifestyle choice. 50% physically assaulted, and that's horrific. And if you have to go to court, if you have to vocalize these issues, what sort of risk are you exposing these people to, and why? So one of the concepts that I came up with, and I heard a lecture a couple of years ago at one of the big institutes that you know on this topic, and I left the lecture. I thought it was, it was well done. It was interesting. It made a lot of good points, but I left the lecture kind of scratching my head. They didn't give me any answers. They told me about issues, but where's an answer? And I pondered it and pondered it, and I came up with what I think is an intriguing solution. And it's actually similar to a concept that I propose to address issues that Muslim clients have, which I can tell you about because it's a similar construct. What I did is I came up with an idea. I don't want to have people put in not just awkward positions, but potentially physically dangerous positions. I don't want to risk having somebody have to go to court, which may cause all sorts of ripple effect problems if we can avoid it. What's the solution? What's a possible solution? What if you appoint you're familiar with a trust protector. Maybe you can define the concept for your audience, and then I'll explain how I use it here.
Well, if you view the trustee of a trust as being the president of the company, you could name a trust protector who could serve sort of as the board of directors of the company and change the bylaws a little bit. So
That's an interesting
typically,
analogy.
yeah, so typically the trust
I'm going to
protectors,
steal that.
yeah, I hope you do. So typically the trust protectors are people who are very trustworthy. They don't run the trust day to day, but they can change the trust when it's time to change the trust. And oftentimes we provide that they need consent from a family member to change the trust. But you go to them and say, oh my gosh, the tax law changed, or oh my gosh, my brother became a serpent. So please change the trust, and the trust protectors change the trust, and
Or
we all
change the trustee, get rid of the serpent.
right, get rid of the serpent. That's exactly right.
So let me have you explain one more concept, and I'm going to piece them together in a unique way that I've never seen anyone do, and tell you how you can use that concept to protect an LGBTQ heir. Can you explain what a limited power of appointment is?
For a limited power of appointment.
I mean, I know you can't. I just, this way I'm not talking all the time because people are
Well, I
starting
know.
to snore. I hear the snoring.
I know. Okay. So a limited power of appointment is a power that you give someone in a trust, which says that Frida at, can can direct trust assets to or for the benefit of X, Y, or Z with whatever limitations you want. And the most common one would be I leave these assets in trust for my spouse. And when my spouse dies, she can direct where they go as long as they are going only for the benefit of our descendants. That's a power of appointment.
And you could make the power what's called a limited power, so you don't have adverse tax consequences. And it could be very broad. Alan gave the most common example is to my descendants, but you could say to anybody on the planet except not to me, not to my estate, not to my creditors, not to my creditors, my estate, the creditors of my estate. So let me take the two concepts that Alan just gave you and show you how to weave them together in a creative way to address what I think are a lot of the toughest issues that an LGBTQ heir may have. If I name a special person, let's say Alan's been advising this family for 30 years. He knows everybody in the family. He's got no axe to grind. He ain't getting any money other than billing for his time. And he's objective and he understands all this stuff. And he's got a soul, which I do know. I can vouch for you on that, Alan. So if I give Alan two roles, I'm going to give Alan a limited power of appointment, and I'm going to give Alan a special limited trust director role that Alan can confirm any distribution that's provided for under my will or my trust to any of my heirs, so that if there's a change in gender or name, etc., he can reconfirm how it's to be distributed. So if John becomes Jane, and the way the will or trust is written, it's ambiguous or even writes them out, Alan in that role can reinterpret the provision and even exercise a limited power of appointment to make sure the assets go to that person. Another application. I have a client situation now. Daughter is a lesbian and married to a woman, and her wife had a child through artificial insemination. There's no genetic material of the child, my client's daughter, in that baby. I've been trying to get an answer from her, and I can't, whether or not she adopted the child. If she didn't adopt the child, it is perfectly possible that that child is not her heir under state law. I can tell you, because I've talked to her, she loves that little kid, and that if something, God forbid, happened to her and her wife, she would want her assets to go to that kid. But she has, I can't get her back in to update her documents. If they had Alan holding both a special trust protector role and limited power of appointment, Alan would know, obviously, that this woman wanted her child to inherit. And just because of the technical definitions of child under state law, it didn't work. And because she didn't come back in to update her documents. And by the way, very few people come back regularly to update their documents and address these issues. Alan should be laughing because he knows it's true. You know, we as lawyers can tell people come back every 3 years, or if there's a major change, and we'll get calls from somebody from 20 years ago. And usually when you get a call from somebody 20 years ago, they start talking to you like you remember who they are, right? Who are you? But that role could solve the problem of a child transitioning. It could solve the problem of a child being born a further descendant from assisted reproductive technology, and a whole myriad of other things. You know, will a trust pay for the cost of transition? Well, is that a medical expense? Is it a necessary expense? How does it fit in the language? The problem is that we have hundreds and hundreds of years of trust law and the science of reproductive technology. The more common, and I'm not sure the right words to use to describe it, but a lot of these issues, if they existed, they were hidden before. Nobody would talk about them. But now they're there. So what do we do if the law hasn't quite kept up? And it hasn't. It's not just the lawyers, it's case law, it's statutes. We're all struggling to keep up with these rapid changes and these new developments. We know that there's just incredible pushback in society now against some of the things we've talked about. So if you designate somebody as a special trust protector to address just these issues and give them a limited power of appointment, they may be able to correct a lot of these issues that even if you went to court, you may not be able to correct. And you don't want to go to court because of the cost, the publicity, and all the negative ripple effects. Now, should I transition and say how a similar construct can be used for Muslim clients?
Sure.
So
Yeah.
just for context, we were talking about different types of distributions, equal, non-equal, what's equitable. Now we're talking about some of the other human aspects that can come up. We talked about some of the LGBTQ issues. We had earlier mentioned religion. Let me tell you about religion. I find it disturbing that in the LGBTQ world that the statistics are as awful as I cited a minute ago. Let me give you a statistic about religion that's deeply disturbing. There's, I believe, over 200 bills that have been proposed around the country, and it may be higher now, and some of them were enacted. I don't know what's left in force, but just the mere concept should be disturbing to anybody. Our country was founded on the basis, in my understanding, of religious freedom. You know, you can worship how you want, just don't tell me what to do, right? But the anti-Sharia legislation, so legislation, at least 200 different bills plus, have been introduced around the country over the years to prevent the application of Sharia law. If a Muslim family wants to leave their assets according to Islamic law to their heirs and define heirs under Islamic law as the Quran provides, why should that concern any of us? Why is that not their right of religious freedom? Yet laws have been enacted throughout the country to potentially restrict that. I didn't say that correctly. Proposed. I don't know how many have been enacted. But it's certainly a risk, especially with the direction our country is going of people seemingly becoming less tolerant instead of more tolerant, that those issues could arise again. And hey, by the way, if you're Orthodox Jew or a fundamental Christian and you want to leave assets based on biblical law, these rules are so broadly written, they will prevent you from doing that as well. So it goes beyond just Islam, but let me explain it in that context. If I want to assure that if I have an issue, that the assets are distributed pursuant to Islamic law as I wish, if that's my wish, I don't want to risk going to court. One, because the publicity. Two, because how can a secular court understand this? Three, if you're not familiar and we don't have the time for it to delve into the nuances of Islamic inheritance law, it's quite complex. And depending who's alive or not alive at the time of death, the various specified fractions can change. So you almost need a Muslim scholar, really an imam, to interpret what should be done. And you don't want a secular court trying to do that. It's not right. It's not what you want. And if you're a fundamentalist Christian and you want, certain religious values infused into your plan, you don't want a secular court interpreting those either. So in this context, if I name, and you'd probably want a Muslim scholar that understands this, that's independent of the family, no axe to grind, and give them the power as a special, let's call it Islamic trust protector, to interpret the governing document so that it works under Islamic law and applicable state law, and give them at the same time a limited power or special power of appointment to appoint to my Islamic heirs or heirs under Islamic law. If there's an error in the drafting, if there's an ambiguity, if there's a lack of clarity, they can reinterpret the document to make it work. And if that doesn't suffice, to avoid going to court, especially under the potential of this atmosphere of these anti-Sharia laws, they can exercise the limited power, just like we described in the prior scenario, to direct the assets where you want them to go. And they can't really abuse it because it's limited to Islamic heirs. And now, I don't want to get too technical, but just if, you're allowed a certain percentage of the estate to go to non-Islamic, non-Quranic heirs, like whoever you want. So maybe you limit the power to just the percentage that is not governed by the flexible piece, and so on. But the point is that when people have strong religious lifestyle or other preferences, why can't we respect those and go a step further and make sure that it's not going to be a legal battle, an ugly, costly legal battle often, to have to implement or enforce those things later?
Beautiful. Beautiful. You spend a lot of time thinking about things that just don't get thought about and don't get written about. So that's why you are who you are.
I find that it gives me great satisfaction if I can help somebody avoid the trauma of all of this. It gives me great satisfaction when I study and understand something to try to help somebody on this level, because I think it's like the ultimate respect to show another human being, where you care enough about their religious values, personal lifestyle choices or decisions, lifestyle decisions, to try to be respectful of them. And honestly, if we could all just treat each other in that way, what a wonderful world it would be.
Yeah, in the modern world of how many estate plans can I do this week and how soon can I get them done, we kind of forget to take care of people, which is really what I think you and I are a little bit more about. I want to take care of people. I want them properly treated, and I want families to flourish and not be at each other's necks.
I think if I can step back and be philosophical for a moment, and you can tease me and others may as well, but we have a unique profession in estate planning. And I'm not limiting it to lawyers. I'm talking about everybody broadly in the estate planning arena. but especially the lawyers. We're drawn to this profession for two reasons. One, I think there are very few other professions in the world that have the intellectual challenges that estate planning does. If you just listened to this webinar podcast, I don't know how what to call it or how long it's rambled on for, but the breadth of and depth of areas that we've talked about, and we haven't even talked about complex GST planning, a grantor trust, the amount of knowledge that we have to have as an estate planning attorney is tremendous. And I think there's clearly one of the two major motives that draws people to this profession is it has incredible intellectual challenge. And when you look at the topics we've talked about today, if you have intellectual curiosity, I mean, there are just so many different things that you can have to delve into as an estate planner. And the second thing, which Alan said, and forgive me for being so kind, but very eloquently, is that I believe the second factor, and I'm not sure which is first and which is second. One is the intellectual challenge and stimulation, but I think the other are the two factors. Maybe they're equal. Maybe this one is more important. That draws people to become estate planners is the ability to help people. We really, really can help people. Listen to all the different topics that we've just talked about today. In every one of those topics, we're helping protect somebody. We're helping somebody with a health issue. We're making people's lives safer, more comfortable, respecting their religious or other personal beliefs. We help people. And I think that if you really want to thrive, and if you have thrived as an estate planner, you have to appreciate and get juiced by the intellectual challenges. And you have to get juiced by being able to help people. And I think that's what keeps us here. And, you know, it's interesting. I was on a study group call a couple weeks ago, and I turned 65 this past December, so I felt that it was time for me to start planning what I'll call the next phase of my career. I didn't say the last phase, but the next phase, which I want it to be different than the last phase. And I asked the people on the call, because there were only like 8 of them, could I ask you all a personal question? They said, sure, Marty. And I said, what are you all thinking about in terms of retirement plans? And then it dawned on me after I asked the question that the next youngest person on the call was probably about 78. And they were ranged from 78 to 85, and they're all still working. And it was fascinating to hear their comments. But I think it's the two factors that Alan and I just talked about, the intellectual challenge and curiosity, and the real ability to help people, which is why they're still there, because those are great things, right?
Yeah, yeah. And they're important in every profession, and so it's so often lost in every profession. So,
Yeah.
well, Marty, this has been absolutely fantastic. I hope we'll be able to do this again sometime very soon.
Alan, we didn't go through the slides yet. Don't we have to go through all the slides?
And it was wonderful. There were no slides. You have a
There's
lot of slides there, though, right?
We don't need the slides. I think this was much better. And by the way, this really proves a point. I think by us just talking, we got to a much better place to demonstrate the importance of the human aspects of planning than had we gone through any slides anybody, especially me, created. And that's the point that Alan kind of brought out when you have, and I tried to elaborate on, when you have an initial meeting, don't have an agenda. Don't tell somebody, if you're a client, what kind of trust you want. Talk about you, your life, your goals, your dreams, because understanding who you are and what's important to you and what's not important to you is what will help craft a plan that really does provide what you need and want, both. And needs and wants are often very different. So I think what we did on this web conference is exactly what you want to do if you're a client when you sit down with your planners. And please don't just sit down with your attorney, bring your accountant and your insurance consultant. The more the better, because each of us looks at life through a different lens, not just professionally, but we're different people. And if Alan and I are both meeting with you at the same time, just as an example, he's going to sense and see things that I'm not going to sense and see. and I'll probably see some things through a different lens than Alan. So bring in several people, because that's what's really going to get you to what you need and want.
Right? You can have a great synergism and a great mastermind, and you go to somebody like Marty Schenkman, who's done this for 1,000 wealthy families, you're going to learn something.
I thought you were going to say
you're not
1,000 years, and I was going to say I look that old.
Marty, one last time, how can you be contacted, and where can we watch your videos?
Don't worry about contacting me. I appreciate it. But Law Easy, LAWEASY, has, like I said, about 180 10-minute planning video clips, and I'm adding to it all the time. Alan, you and I should do a series on human aspects of planning for that.
Yeah, love to do it.
And the Schenkman Law website has about 150 webinars and 300-400 articles. I actually haven't counted, but a lot. So there's a lot of material there, and I add to it all the time. And if you're on this call and you have existing advisors, by all means, feel free to take any of the ideas or materials and go to your advisory team and suggest that they discuss with you those things. Hopefully it'll help you. And if you're an advisor, hopefully the materials will be a good resource for you as well.
Beautiful. Marty, thanks again. Really appreciate it. And I'll definitely share with you all the feedback, and there'll be a lot of feedback. So then we can do something very soon together.
This was great, Alan. I definitely want to do more with you.
Fuck. Who's calling who a dummy? You're a dummy. Okay. Well, I hope everybody enjoyed that talk. Marty Schenkman is certainly a wonderful guy. You can visit his website, see his videos, and have a fantastic rest of your weekend. We will see you next week when we can and as we can. Thank you. Thank you. Bye.